looking at here realistically? And first of all, we'll talk about that and then I have a follow-up.
I don't think there's any way of really predicting when the court will decide, but it will certainly be a while. It will not be this year, but sometime, hopefully early next year.
And to follow up on that, both sides have basically said that if they lose, they would take it to the U.S. Supreme Court. So that seems to be a given. With that in mind, how far away are we from having Proposition 8 finally decided definitively once and for all? Are we still a year or so away, you think?
If it goes to the Supreme Court, if the Supreme Court accepts it, yes. And if they seek Supreme Court review, which they said they will when they lose, then there will be a period of time, 90 days, while they seek that, even if the Supreme Court were to deny review.
So worst case scenario as far as length, what do you figure?
Sometime in 2012.
On the standing issue, do you expect the California Supreme Court to get involved in this, as the judge suggested?
I think that if the court were to decide it on the standing issue, that is the least likely for the Supreme Court to take the case.
I'm talking about the state Supreme Court, I'm sorry, with the plaintiffs and the question of standing, and the whole issue of the governor and the attorney general.
Do I think they're going to certify it to the Supreme Court? I wouldn't want to try to opine on what the court's going to do.
What did you make of that, those questions, though? What do you think that means? Were you surprised by that line of questioning?
No, because the Supreme Court and this court have said that a necessary but not sufficient condition of allowing somebody to intervene on behalf of the state is that the state specifically authorized them to do that. My argument to the court was even if that had happened, and we don't think it has, that is not sufficient, and they still would not have the concrete, particularized, personal injury that the federal Constitution requires for standing, because they have absolutely no evidence that this hurts them in any way. And if it doesn't hurt them in any way, the Constitution says there's no case or controversy and they shouldn't be in court. So even if they were authorized to do that, a state can't authorize somebody to have federal court standing. So what I was saying was that we don't think there's any real doubt about the state law issue. The state has not authorized them. There's no law that says that. In fact, the Supreme Court said they do not have standing. Intervention is a different question. There's a little bit of confusion between intervention and standing. The standing issue is separate from the intervention issue. So we don't think there's a confusion about state law. But even if there was, we think that would not be sufficient. So our argument was you don't need to do it, but whether the court agrees with that or not, it's up to the court.
Yeah, question over here. Can you stand up?
Rules that there is no standing, or possibly later the California Supreme Court rules there's no standing, could this court go ahead and decide the constitutional issue anyhow, just to clarify, even if it says there's no standing?
The court could. The court could.
On the non-standing issues, can you put in your mind the strongest argument that you feel your opposition and what you feel their their argument is to the justices?
I'm sorry. I really can't. I mean, one of the problems that we've had from the beginning is I don't know what the argument is on the other side, other than a label. I don't know what the argument is on the other side, other than a bumper sticker that says marriage is between a man and a woman. They haven't shown any harm. They haven't shown any harm to anybody. They've admitted that banning marriage equality harms millions of people and the children that they're raising. So I don't know what the argument is.
There seemed to be a suggestion from a couple of the judges that they were interested in looking beyond the findings of fact in the trial record from Judge Walker's court, and maybe going out into the world and looking at all the facts in the world or something, legislative facts to help them decision.
Sure.
What do you think about that?
I think they were making that point because our opponents had nothing else to rely on. We had a trial in this case, a 3-week trial in this city, They were invited to put on whatever witnesses, fact witnesses, expert opinion witnesses, and so forth that they felt were important to the case. After a couple of them were deposed by David Boies before the case, they withdrew those witnesses. And then the two that they did bring into court, David dismantled in a very nice way, in a very nice way. And as a result, they offered to the court for what's called judicial notice, vast amounts of library materials. Maybe they got some in this room, but I don't know where they all came from. But David's made the point, and I should allow him to make it, but he's maybe too modest to make it, that we have a trial so that we can test the credibility and intelligence and logic of the people who are offering evidence. We offered expert witnesses. We had 12 or 14 witnesses in this case. They cross-examined those witnesses. The judge made findings as to their credibility and to the validity of the facts and opinions that they testified to. That was the evidence in this case. So when we came to an appeal, our opponents had to say, oh, none of that matters, because we're doing something called legislative facts, which is a vague term, which basically means, you know, things about whether the world is round and that sort of thing, as you pointed out. The facts of this case came in the form of evidence and was tested in the crucible of cross-examination in a trial, and I think the judges were asking about that because the proponents didn't have anything else to offer.
Can you address how this is going to play out? You talked about it applies just to Alameda and LA County, but it really would apply to the entire state if Judge Walker's ruling is upheld. So how does that play out in this state and across the nation?
This judgment goes to the governor and attorney general of the state of California, who are the chief law enforcement officials of the state of California. They are bound by the district court decision if it's affirmed or if the appeal is dismissed. They are responsible to make sure that every local and municipal official of the state of California complies with the law. So they have a responsibility to make sure that county clerks, county registrars, mayors, city councils, board of supervisors, everybody complies with what the court has decided and order them to comply with. And they have made a decision that it is in the best interest of the state of California not to pursue this case further. They came in courageously and said, we don't want our citizens subject to any more discrimination. We've had a trial, the judge made a decision, that's the end of it. And so there was a lot of talk about county clerks and that sort of thing. It basically boils down to the persons that the officials that the citizens of California have put in the top law enforcement positions in this state, and they will have the responsibility to enforce that judgment.
Take two more questions.
This isn't the first time in history that who can marry who has been debated 20, 30, 40 years from now. How do you think this particular moment in history, not just today, but the whole leading up to today and beyond, will be taught in this state?
I think this is a turning point. I think that looking forward 20 years, 30 years from now, people are going to wonder, why was this necessary? They'll look back on this the way we look back on Loving against Virginia and say, how was it ever possible that people debated whether everyone ought to have this fundamental right? So I think that people will look back at this case the way we look back on Brown against Board of Education and say, why did it take so long?
Can you talk about, based on the questioning from the judges, is there any clear indication if this will affect just California, or will it be a broad scope? And one of the justices, I think, was talking about what would happen for, let's say, for just domestic partner rights.
I don't think, maybe Ted does, I don't think that you can tell how the judges are going to decide this. They could decide this on a whole series of grounds. They could decide that there's no standing because the appellants, the people who have brought it to this court, haven't had any concrete injury. They haven't shown any concrete injury, and so that's the end of it. They could decide that they're going to grant standing, but then decide that based on California's particular facts, it's unconstitutional for California to take away a right that had existed in California, particularly in the context of the broad domestic partnership law and the broad recognition in California that all citizens are equal and all citizens have the same rights to relationships and child raising. Or they could decide it on grounds that were applicable nationally. I don't think that you can predict what the grounds would be.
I'm not going to add anything to that answer because it's not profitable for anybody to start guessing what judges are going to do. They'll do the right thing. They were very well prepared. They asked very incisive questions of both sides. I'm so glad that it was televised because the American people could see what the issues were. They could see our justice system in operation, asking intelligent questions, probing the lawyers from both sides. You can't take too much from the questions asked because the judges feel a responsibility to probe all of the issues made by both sides. So that was very, very gratifying to see that. And I wanted to say one more thing. Chris and Sandy and Paul and Jeff, our plaintiffs, our clients, the people that have had the courage to bring this case and who've been standing behind us and pushing us forward are here, and I want to make sure that you see that they're here, and we thank them for their support and everything that they've done. It's not the easiest thing in the world to be a plaintiff in this case, and I want to thank Chad and all of the people at the American Foundation for Equal Rights, because this takes great courage to bring this case. It takes a lot of resources to pull it together, and they have been fantastic. What a wonderful board of directors and an advisory board. And I want to thank Dennis and Terry, because the city of San Francisco at our side from the very outset of this case has been an extraordinarily important force. They've given us great advice, they've given us great support, and they've been very, very effective in court. And to the extent that we have a successful outcome in this case, it's been a great team working together. The plaintiffs, the American Foundation for Equal Rights, the City and County of San Francisco. It's been, I know David and I both feel the same way. It's been a very touching experience for us. We're not done, but it's been a wonderful experience, and we think we're headed in the right direction.
Thank you.